The common defenses to a hit and run charge, basically what you have to do to realize what the defenses are for hit and run is realize what the elements are for the government to prove a hit and run. Most traffic offenses are not required to prove that you have a guilty mind or that you knew you did something. Okay, it's what they call strict liability offenses. So in other words, you get stopped for speeding, the government doesn't have to prove that you knew you were going over the speed limit. They just have to prove that you were. Okay? It makes it easier to be convicted of those types of crimes. But hit and run in Georgia actually does require the government to prove that you knowingly failed to stop at the scene of an accident. Okay? If they can't prove that you did so knowingly, then that is a fantastic defense for the crime of hit and run. There are requirements on a person once they've been in an accident where property is damaged, where a vehicle that's driven by another human being is damaged, obviously where there's serious injuries. And that's what the hit and run statute imposes upon every Georgia or other state driver who's in the state of Georgia driving while an accident happens. It imposes requirements of staying at the accident site. But one of the exceptions is as long as the traffic will not be seriously impeded. So for example, you get in an accident on 85, if you just sit there, you're going to ruin the whole city's day. They don't want you to do that. So that would be a potential defense. I pulled away because I was impeding traffic. Another, again, is that you didn't knowingly fail to give your name, information, insurance to the people on the scene, or there was no one there perhaps for you to give the information to. What if the other party drove away? That's another good defense in a hit and run case, but most of these things are focusing on whether you knowingly failed to do the thing that you are accused of doing in a hit and run.